Public employees are protected by the First Amendment against retaliation by their employers when they exercise their First Amendment rights. The Supreme Court has decided cases that have restricted the area of protection for that free speech again and again down through the years. Marvin Pickering was a school teacher, and he wrote a letter to the editor of his local paper commenting upon local school district spending issues. He was taking positions that were adverse to those taken by the district officials, and they didn't like Pickering's letter and they fired him. He brought an action claiming that his termination had violated his First Amendment rights to free speech, and the Supreme Court decided that he was right and he had a First Amendment right to speak out as a citizen on a matter of public concern. The two big Supreme Court cases since Pickering have been Connick versus Myers and Garcetti versus Ceballos. In Connick versus Myers, a case involving Harry Connick Sr., the district attorney of New Orleans, an assistant district attorney in his office had spoken out about office management and circulated a questionnaire that could be read as critical of the management of the New Orleans district attorney's office. And she'd been fired for engaging in that kind of expressive activity. The Supreme Court said it was probably legal to fire her because she was talking about matters of purely private concern to herself, which have much less in the way of First Amendment protection from retaliation than overarching political issues like in Pickering, the finances of the entire school district. And that case started a trend among the courts of looking at whether an employee's allegedly protected expression for which the employee was alleging retaliation was a purely personal grievance. And if it was a purely personal grievance, it was not protected against retaliation. From the Connick versus Myers case, you need to ask whether the employee is speaking on a subject that is of legitimate public interest. But then we also have to look at, after the Garcetti versus Ceballos case, whether the employee was speaking pursuant to his official job duties or her official job duties. If they were, then they're not going to be protected. Only speech outside of one's official duties is protected by the First Amendment after Garcetti.